I don't know. So coming back to that, because I couldn't record it, I forgot to record it. See, for a person who is domiciled in a Goa, it will be Portuguese code which will be applicable, which has been adopted by Goa and Indian government for application in the Goa. The question came before the Supreme Court was that if the property which is suppose outside Goa, suppose in Bombay, what is a law which will be applicable? Of course, in the dispute which I am right now referring to, I am going to take you through that. In 2-3 minutes, I will take you through that. Supreme Court very clearly came to the conclusion: if a person is domiciled in the Goa, then it's for all his property wherever it is there, it is a Goan, that is uniform code, Portuguese code will be applicable. So even if for a property which is in Bombay, the same code will be applicable. Why? Because after interpretation the Portuguese code, they have come to that conclusion. What is their code says is that after there are many others, I will take you through briefly that topic now. I will go take you through the judgment. Basically, what it says here is that once a marriage takes place, then individual property of husband and individual property of wife becomes their own property together. That is what it happens in that. And they, for Mohammedans over there, they cannot own more than one wife, which the other places they can have more than one wife, 4 wives. So all those things are not applicable to the Goa. And now when we are talking about uniform civil code, now a lot of talks is going on, and I'm sure more or less before this election, maybe it's a matter of few months, the uniform civil code, probably what I can see, the way government is moving, they are going to bring, it seems, uniform civil code. Even in the judgment which I am referring to, even a judgment which I am referring to, in that also Goa, the Supreme Court has commented that despite their provision which requires that we should have a uniform civil code, nothing has been done in last 50, 60 years. So I will just take you through that provision, that particular part of the judgment in 2-3 minutes, and then what court has come to conclusion, and that will shift it to back to our webinar. Means the other topics which has remained. Just sorry, just let me screen share. All of you are able to see? Just a minute. Just a minute. Just a minute. Okay. You are able to see? See the question. See the question before the Supreme Court. This is a judgment of, you can note down also. And in fact, I wanted to share it. But the way all the people had joined that group, I don't know. Somehow I restrained myself not putting. Just take down the civil appeal number 7378 of 2010. Jose Paulo Coutinho versus Maria Luisa Valentina Pereira. I will share, don't worry. So these are the questions before the Supreme Court. There is a question before the Supreme Court, and this is I will just go through it first. Whether the Portuguese code can be civil code can be said to be a foreign law and principle of private international law are applicable. Whether property of a Goan, understand this, property of Goan, domicile outside the territory of Goa would be governed by code or by Indian Succession Act or by personal law as applicable into rest of the country. Hindu Succession Act, Muslim Personal Law, Shariat Application Act, etc. Okay, this is basically question. Now we will directly go to the question relevant to us, which I was just now discussing it. Now, just I am putting out so this thing. So whatever is there in the judgment, and so I am not talking about any politics or anything. So in this judgment, and I feel rightly so, because that is what is a requirement of time. It is interesting to note there, whereas founder of Constitution in Article 44 of Part 4 dealing with the directive principle of state had adopted and expected that state shall endeavor to secure for citizen a uniform civil code throughout the territory of India. Till date, no action has been taken in this regard, though Hindu law were codified in 1956, there has been no attempt to frame uniform civil code applicable to all citizens of the country, despite exhortation of this code in case of Muhammad Ahmed Khan versus Shah Banu and Sarla Mughal versus and others versus Union of India. So basically, Supreme Court has clearly come to was of the opinion there has to be uniform civil code, because that's what our constitution says. We are a secular country. That's what our constitution says. And then till date, means 60 years after that, this is of 2017 or some judgment, 60-70 years, 60-17 years, 67 years, still we are not made any attempt to uniform civil code. So that's what even Supreme Court says. Now government, I think, is serious and looking at the way government is proceeding, probably they will take it forward. Now coming to our question, which is there. See, after going through all those things, why civil code is a civil code means they are talking about Portuguese code. Once we have to come to the once we have come to the conclusion that civil code is in Indian law and domiciles of Goa for all intent purpose are Indian citizen, would it be prudent to hold that civil code in a matter of succession would apply only in respect of property situated within the territories of Goa? We do not think so. Then succession is governed normally by the personal law, and where there is a uniform civil code as in Goa by civil code, only Article 24 is not to be taken into consideration. Then it would be obvious that all property, whether within Goa or outside Goa, must be governed by civil code of Goa. If it were to hold otherwise, consequences would be disastrous, to say the least. There will be no certainty of succession. It would be virtually impossible to determine the legitimate, which is I don't know how it is pronounced, legitimate, or basically it's a legal person who is entitled to the succession. Legitime, which is in an inherent part of law of succession. Right of spouse to have 50% of the property could easily be defeated by buying properties outside the Goa. And in case of Hindu Goan domicile, it would lead to further complication, because if it were to accept the judgment of learned single judge and argument of the respondent for the properties in Goa, civil code would apply, but for properties outside territory of Goa, Hindu Succession Act will apply. Similarly, for Muslim within the state of Goa, code would apply, and outside Goa, Muslim personal law would apply. This would lead to many uncalled for disputes and total uncertainty with regard to succession. There must be unity of succession, and Portuguese law, that is again is talking about those things. So basically, I'm not going to because it will take time. Basically, what it is saying is that for all purpose, if a person is domiciled in Goa, it's a uniform civil code. The code which is applicable to him will be applicable to all its properties. So basically, this is what basically Supreme Court states in respect of a person who is domiciled in Goa. So that's what I want to talk about. If any have a question, it's open for it. So it's open. Anyone has any question on this? No question. So I'm clear, right? Now, what is it, Geeta, you want? I mean to say. So basically, if a person is having a property, if a person, see, a question is that whether to a person who is holding properties outside Goa also, what is a law which will be applicable in case of succession? Basically, that's the question. Whether there is no dispute that a person having a property domiciled in Goa, Goan law is applicable. That means uniform Portuguese code is applicable, which is basically uniform civil code. Whether same, sorry, whether same will be applicable to its property which are outside the Goa. Court came to conclusion even in respect of property outside a Goa for a Goan who is domiciled in Goa, Goan uniform civil code, which is a Portuguese code, civil code will be applicable. So any what you want? Anything else, Geeta? If non-domicile Goa as property in Goa, see that's what the issue is that what is domiciled in Goa? Basically, is the domicile who is a Goa is a person who is basically native of Goa. Like we have here the process of getting domicile certificate for them, it will be applicable, but not to other person. So if person taking this same analogy, it will be for a person who is in Goa but not domiciled in Goa. It will not, is my opinion. I have not come across this any question on this, any judgment on this. But in my opinion, making application of the same judgment, it would be if it's a Hindu, it will Hindu Succession Act will be applicable to the properties which are in Goa if it's not domiciled in Goa. No, Geeta. Means outside Goa, Hindu and Muslim personal law board will be applicable. No, I am talking right now. We are talking about the succession, Geeta. For succession, it's going to be Portuguese civil code. That is uniform civil code will be applicable for his all properties even outside Goa. We are not talking about personal law over here right now. We are not discussing that. We are just discussing on the succession law. Because that judgment is of succession law. Okay. So now let's come back to our topic, Succession Act, which I wanted to discuss. One is that, as already told on last occasion, that it will be applicable to Hindus, Buddhists, Jains who are there, and other people also, those who are legitimate child of a person who are legitimate child of even sorry illegitimate child of if the both father and mother are Hindus, or even one of them is Hindu and they are brought up as a Hindu. So Hindu Succession Act will be applicable. When we are talking about succession there are two different ways. For succession of male, separate criteria is applicable. Succession of the female, separate criteria is applicable. Even earlier, before amendment to the Hindu Succession Act, which happened in when was there amendment to Hindu Succession Act? Can anyone tell? Put on the chat box. Yes, Neha. Yes, Devidas. Good. Appreciate. See, Hindu Succession Act was amended. Section 6 was amended. And what else in addition to section 6, what was amended? Can anyone tell? Ravindra, it was 2005. Anyone can tell? I'm into the major amendment. There are many such things, but one of the important, which was else other than section 6. Yeah, Manek. That is right. That is to the section 6 of the Hindu Succession Act. No, that is section 6 talks about it. Okay. See, there was also amendment by which section 23 was deleted. What section 23 was telling was that in respect of residential property, a doctor could have not asked for even the partition, or she will not have any right. Even that was one of the very important provision, and often on that basis a lot of dispute used to take. So even that has been deleted. What section 6 has made is that earlier daughter was not co-parsoner and she had no right in the she had no right to ask for division of co-parsonary property. Undivided, sorry, HUF property. She had no right to ask that. But now, by amendment in 2006, she is now co-partner, and if she is a co-partner, then she has also a right to ask for partition in respect of HUF property. Now, my one question which I am asking you is that oh, sure. The question which I am asking you is that suppose a person dies, he was holding a property, and it comes to his three, less for our discussion, two son, one daughter. Now, son have got further sons. Whether, so their property they have got it from their father, means grandson has got, the grandson is there now, his father and his grandfather. So grandfather has expired and now property has come to his son, sons and daughter. Can the grandson ask his share in the property? Okay. Okay. Just taking furthermore the question. Answer is right. Is anyone willing to tell me why it is so? His father, let's say his father was having that co-partner right or HUF right, which percolated down to these children. So why anyone is willing to tell? Because upon death of his father, he will get the right, vested right. To certain extent, yes. I will not say wrong, Neha, you are. I will tell you why. See, when such situation happens, these are judgment of Supreme Court. In fact, I want to share it. Rakesh, just note down the name of everyone, just if you can. You are also, because I don't want it to this. Yeah, what is that? That is a one. There was a judgment similarly in which this grandson filed a suit for partition, saying that this is an HUF property, so he has a right in the property. Supreme Court categorically came that no, you have no right in the property till your father is alive. What there are several judgments on this issue. What Supreme Court has come to conclusion is that moment that partition or inheritance takes place, it becomes self-acquired property. What it becomes? Self-acquired property. Once it is a self-acquired property, you have no right to ask for further partition. So when he gets by partition the property, and it becomes a self-acquired property. The reason rightly so given behind this is that had that not been a case, when I will give Aruna. That's what I told them. Yes, Sachin. Had that not been case, when a person dies, see what we saw is that when a person dies, his legal heir basically you will see that section, I think section 8.9, yes, 8.9, is that his legal heir basically who? His son, daughter, mother, and son, daughter, mother, and wife, basically. There is legal heir. They have given, means their grandson, means son become legal heir only if his father is not there. So legislation intention was very clear on that in type of codification, that his son will not have a right per se. So right is given only to the father. So on that basis, Jigna, that on that basis, Supreme Court has come to conclusion. It is only that father property, once it comes to him by a partition, it becomes a self-acquired property, and then you will have no right to the property. I will share. Yes. Sorry, I'm just scrolling down. Just a minute. Sorry. Right. So last occasion we already saw that fathers. I think there is no difficulty in understanding the succession in male, right? The simple is that property goes to, when a person dies, is that son, mother, daughter, and son, mother, her son, daughter, mother, and wife. When a man die, so wife. Father, it does not go because he is not in a class 1. So if these people are not there, then only we go to the class 2. So comparatively, when we are talking about succession, for men, it's quite simple. But now, again, I'm going through the female. When a female dies, it becomes a little more complicated. I'm not going to the again now. Yes, when a female dies, property goes to her son, daughter, and her husband. There is no difficulty in that. It is equally divided. But if son and daughter is not there, son and daughter I'm talking about, we have to understand how it is done. See, when this act was codified, Hindu Succession Act was codified in 1956. What I can see in that, they are not contemplated that Hindu Succession Act that female can have her independent source of income. So they are not contemplated. So only two things which was contemplated was at that point of time, that either she gets a property from husband or father-in-law, or she gets a property from mother-in-law. Her independent property doesn't seem to have been thought of in this. But then, looking at this thing, it will be have to be considered as her own property, and then it will have to be applicable like same principle will be applicable like her own property. Then there are two provisions which are important to you. Number one, first is that property goes to son, daughter, and mother. Sorry, son, daughter, and husband. So there is no difficulty on that. But difficulty starts when son and daughter are not there. When there are no son or daughter, in that case, the property which is inherited when there are no son or daughter, then the property which she has inherited, if it is from her father or mother, means if she has got that property from father or mother, in that case, it will go to the legal heir of her father, not to the legal heir of husband, not to the husband also. Even daughter and son are not there. Even husband is excluded from her property, uh, for by of inheritance. I am talking in the respect of property which he has received from her parents. Similarly, if property is second provision, it's not second is provision. Similarly, if property which she has received from her husband or from her in-laws, in that case, these are all will come in absence of, these are the all rules will come in absence of there not being son and daughter. And when we are talking about this husband property, we're talking property inherited from a husband or father-in-law. In that case, it will not go to her parents in absence of son and daughter. It will go to, if husband is living, it will go to husband or legal heir of husband. So again, then once we are talking about legal heirs of husband, what we'll have to do is that we have to go back to section 8, how the property devolves under section 8. So how it devolves, one is husband, one it go first is that son, daughter, they are not there. Wife, she is not there. Wife is not there. Even when we are talking about when we are talking about section 8, because now wife is dead. So it is probably only mother who will be entitled to and him. Okay. So basic idea is that where the property came, it has to go back to them. Means if it's from in-law, it has to go back to in-law. If it is from the husband or his father, it has to go back to his father or his father or his legal heir. So now any questions on this? Thereafter, fourth part comes to heir of father and then heir of mother. So that is a other part which will come. But basically, in absence of main person who will be succeeding on the property, they will not get that property will get as per from where she has received the property. And I think when it comes to self-acquired property, I have not come across any judgment to that effect. Maybe I will have to search again on this issue. It is considered as a from the husband's. She has received it from the husband, and it will go to the legal heirs of the husband. That's my opinion. I have not come across any judgment to that effect. So any question on this? What is the status when a female has acquired the property from her son? See, I have not come across any judgment, but applying the same logic, it will have to be probably considered as her self-owned property, and it will go to the husband or his legal heir. Because what is basically basic idea what I can read into that is that from where the property came, it has to go to that. But when you are talking about a lady who is a married, that you can't that point of say that it is exclusively, logically speaking, exclusively her own property. It is to certain extent. I always believe even a husband's property, his wife plays some role in that this thing. And similarly, when it comes to wife's property, if it's from making some earning, he has also played some role in that. We can't say which is specifically that no, they are not made played any role. So according to me, that will be considered as a self-acquired property, and then again it will have to devolve on the legal heirs of the husband. That means the legal heirs of the son or her legal heirs. See, Aruna, again here it seems there is a confusion. When we are talking about a lady who dies without leaving son and daughter, even if there are predeceased son or children, they will come in the first part itself. So their second part will not come. Predeceased son and daughter also includes predeceased son's daughter. So don't get confused over there. Let me give it an example. Let me just explain you with the example. That's fine. Sorry. Just let me just give it an example. I don't know whether I can just a minute. Just a minute. Give me 1 minute. Let me explain you with the example. So this question asked, that should not be a confusion. Yeah. Female, excuse me for this kind of this thing because that is how we can. She had son, daughter, husband. Now, if we talk about, let's take wife and daughter. Now he has expired. You can see, right? Great. Okay. So now when we are talking about female, if this is what her family is, even for our discussion, let's take even she is expired without any legal help, without any children or anyone, without. When he is not expired. So we are talking about a situation where female has expired. She has wife and daughter. Son had wife and daughter. In that case, they fall into the first category. You don't have to go to the second category. The granddaughter will come into the first category itself. It's very clearly stated in this thing. So you don't go into the second category. So is it clear on this point? Mother derives property from father, husband. We'll discuss this, Aruna. We'll just finish this topic which is we have taken up, succession, and then we'll discuss the example which if you have in mind. We'll discuss that. Don't worry. Let me just take. Otherwise, these other things will remain, and then devolution of the female property, which I explained you just now. Now there are certain disqualifications. When a person dies, certain persons are disqualified from inheriting the property. So let's see what are those persons who are disqualified from inheriting the property. One is murderer of the person who has expired is disqualified as to inherit his property. Number two is that if he has ceased to be Hindu, so he has ceased to be Hindu, then even he will not be entitled to the property of the deceased. Even his children, unless his children have adopted again Hindu religion, when succession opens. So just giving an example, I will just give an example. A person suppose dies in 2010. At that point of time, he had two sons. I will just make it simply three sons. Let's go simplify. He had two sons. Out of that, one son had converted to Christian for our discussion. So when he dies in 2010, that is a time when succession opened. So as per this, the person who was converted will not get anything and father's property will be divided into two parts only. Then, because that is the time when succession had opened. Now, is it clear? And what happened? What it says that the law considers that person as dead. So that third son is considered as a dead. But if his son is his grandson is Hindu or is practicing Hindu, in that case, he will be entitled when the succession opens. Now, Just note down what I am telling you. In 2010, a person dies. As given the example, he had three sons. Out of that, one son has become Christian, and his sons are also Christian. But in 2012, suppose take an example, his son, that means the person, the third son who is to become who has converted to Christian, adopts Hindu religion and becomes Hindu. Whether he will be entitled for a share in his grandfather's property. Put in a chat box. Have you understood the question? Whether third, means the grandson who becomes Christian, who becomes Hindu in 2012, will be entitled to the property. Okay. Who else? See, there can be yes or no. That is only two answers. Manju, the question is 2010, a person dies. He had two sons, three sons. Out of that, one son has had adopted, had become Christian. And 2012, his son, means the person who had converted to Christian, become Hindu. So now my question is whether that is a son, and just let me add some more twist into this. 2010, father dies. At this, when he died, he had three sons. Out of that, one son had converted to Christian, and in 2011, his son dies, the one who had converted to Christian, and 2012, the Christian son, there's a grandson, convert themselves to the Hindu. So now my question is that whether that grandson will be entitled to in his grandfather's property. Manju is telling no. No, he has not converted. That fellow has died. Okay. Yes, right, Neha, you are right. That's what basically. See what happens, let me tell you. These are the things which can be explained with the help of examples only. And even if you read the judgment, because you can deal with many of the topics only when you see some issue comes before you. That is when you are going to ask multiple questions, go through multiple this thing. If it is simple, son, daughter, and grandson or something, then there is no difficulty. When these kind of things come, the example which I gave was this. He had a three son. When he dies in 2010, one of the son has become a Christian. Just keep yourself mute. One of the son has become Christian. When one of the son has become Christian, so he is disqualified from inheriting his father's property. So the law which is applicable is that the day when succession opens. So when succession opens, the day the person dies, succession opens. So the law applicable is under 2010 when succession opened. He was Christian, so ruled out, and thereafter also his son, means grandson were not him. So now let me add one more twist into that. Suppose on the day when that person dies, his Christian son has expired. No, his Christian sons are alive, but his sons are Hindu or they are adopted Hindu. In that case, what will be that? Whether the grandson will be entitled for any property, share in his father's property, grandfather's property. Okay. See, the example which I have given here is that means what the section say. I have not come across any of this judgmental. Let me tell you, could be there which it comes, or maybe I have not come across. According to me, the when I gave this example, the section says that section what says is that section says that section says that he is deemed to have expired and died before the interstate. Means in such side of situation, that third son will be considered as dead. So when we are talking about the person who is dead, then his grandson, I don't know how these people are unmuting themselves. Then what happens? His grandson, when the grandfather died, are Hindu. Understand this. So the day succession opens, this grandson are Hindu, and as per this section, what it has to be considered as that the person had died. So he has died, but if his descendants are Hindus, then he will be entitled to. If not, then will not be entitled to on the day when succession has opened. There is 2010, his grandsons are Hindu. His father was a Christian, but his grandson was Hindu. So as per this section, his son will be deemed to have been died. So according to me, the day succession has opened, those grandson will be entitled to 1/3 part of his share. Okay. Any question on this? If someone wants to, they can. I'm just talking about going through this session, my logical thinking on that. What is not clear? Jigna? Jigna. Jigna, you can see once more recording. You will understand what I'm speaking. I will load this in the recording. Okay. So this is basically certain person are disqualified. Then now further Hindu Succession Act, when we are talking about, it also talks about in case of preferential right when two person gets when a property devolves upon the two persons, and it specifically says class 1 person and preferential right to acquire the property. What it basically tells is that if a property is inherited by two persons, suppose are two persons, in that case, if other person is desirous to transfer the property, sell the property, then a right of preemption goes in favor of other person, that other legal hand. So one example which very simple, which I will give is that when father dies, only he had two sons. So they had a property in all in which both were staying together. So they had 50-50 share in the property. But suppose the son, one of the son wants to sell his 50% share. In that case, the other son, the one who is selling or one who is staying there, has a preferential right to buy his share, means his brother's share. For our discussion, it's a brother share. He will have preferential right when he want to sell the property. And what could be the consideration between them if there is an agreement? There is clear understanding. Yes, I will sell my share, 50% share for suppose 50 lakh rupees. If both other brother is also agreeable for that, then fine. Then that is a rate which is fixed, mutually decided. But if it's not agreeable, in that case, an application can be made to the court, and then court will have to decide what is a fair and reasonable consideration. Honestly speaking, I have not seen any such case up to now. And what way court will think on that, I have not seen. Maybe I didn't even go try to find out judgment also. But that basically is that because third party, before a third party comes into, the existing co-owner should be given a preemptive right. That is even when we come talk about the transfer of property. But other question which comes into mind, I gave that he had left one house. But whether same rule be applicable when he has left two different houses and they individual become owner and he is selling his flat which he has received, whether at that point of time, whether right of preemption can be invoked, I have my own doubt. Why I am telling? For this reason. Suppose a person, just take an example, just hear me out what I am talking. A person dies in 2005. He had two sons, he had two flats. I am just simplifying this. So one flat was given to one son and another flat was given to another son. And there is no dispute, value of both the properties are same, both the flats are same. Now, my question is, person has died in 2005 and in 2010 he wants to another person who got another flat, he wants to sell his flat. So now my question is whether other son, means the son who is the son who is not selling, whether he has a preferential right to acquire the property. So just see, this session per se say that he has a right to do that. But check out again yourself whether he has right to do that. If object which I can see is that in the instance which I gave you example, illustration, I feel he will not have a right of preemption. But section says if it is inherited from this, then he has right to acquire that property, preferential right. If it is a joint business or something, I will have no dispute. But if it's totally separated property, I didn't see any exemption. That's what I didn't read it. So in that case, see, these are the questions which is arising in my mind when I'm talking to you. Had this question come case law or someone had come for my opinion, probability is that I would have gone further probed into that. Just a minute. Just a minute. Just a minute. There is no distinction. There is no distinction as such made in the joint property or something like that. Interest in immoral property is shown your divorce upon it who are more specified of the schedule. It could be what is Sachin saying could be right and could have to we have to see check up. Section 22 deals with the things which I am talking about right now. So you people check up on that topic and you can give a comment on that. So basically, I am doubtful about that section because I didn't see any judgment to that effect. So it's again open for discussion. So this is what basically a Hindu Succession Act in brief. Let me tell you, there are multiple questions, multiple things come up on this topic. While talking with you also, many things came in my mind, which I didn't discuss with you, but many questions arise in my mind also. So more you do it, more you will try and understand about it. And particularly when you yourself get a case, that is the time you are going to get into that, do a research work on that. So that was my attempt to explain you what is the Hindu Succession Act. If you have any queries, you can ask, or if no query, we can stop here. Rakesh, just I'm wondering how to share the things with these people because many people are
So we
joining
can
it.
we can share the link of the group which we already created. Because if someone who has joined only for today's session, he will
Uh,
also get opportunity to join.
एक minute. Then can you create immediately?
We'll share the link of the group which we already created, HUF
But
group.
then problem is that there are many people who are not there, who are not attending this.
Okay, I will create the group
Just
and share.
2 minutes. 2 minutes hold on. You will create and put that in the chat box. In the meantime, any question? Or today I got one query from someone from the group. I'm not naming them, but I will just share with you what is the query was. What was the query? The query was in respect of inheritance of a female who had died intestate. Now, hear me the question, sir. Hear me the question. Question is, a person was there who was in army and his wife. The concerned person died in 2008 and the lady died in 2023. And the person's son died in the year 2016. Just hear me out properly. 2016. And he had one son and one daughter. Now, son had wife and when he died, leaving behind his legal heir, his wife and his daughter. And that means the original person means original father had one daughter also. Now thereafter in 22 even mother expired. So the question is number one, how much share will the daughter get in the property? The properties are, one are movable properties and other are some bank accounts. In respect of bank account, in one account he had appointed, or she, that lady had appointed a daughter as a nominee. In another couple of accounts, there was no nomination there. So now my question to you is that how much share who will be having? And can as a daughter, as a nominee, entitled for whatever money which was there in the bank account? If you can post your this thing. See my okay. If you put answer, see, I am again repeating. There is no right. You don't have to bother that there is wrong answer or right answer. I mean, if there is a wrong answer. Yes, all of you just join this group chat which Rakesh has put. See, nominee is entitled to immovable property. No, first is that what share in that is nomination. I spoke about the bank. First concept, clearly keep it in your mind. Clearly, nominee is just a trustee. Please again keep it in your mind. Nominee is a trustee of the legal heirs. He doesn't get a right in the property. He is just a trustee. That is number one. You always keep in your mind. So when we are talking about the property of a person who has died intestate, so first is that father died. When father died, the property get divided into three parts. Because who he had son, daughter, and wife. So all get 1/3 part. So now when mother dies, means the lady dies, if you see the rule, her share will be also equally divided between the son and daughter. Widow, daughter. Yes, right. So her 1/3 share, whichever was there. So again, it will be divided between son and daughter. But in our situation, what has happened is that son is not there, but he has a predeceased daughter. So predeceased daughter and wife will get a share. Okay. So basically, again, it will be the property will be divided 50-50%. Okay. Means daughter will get 50% and rest of the 50% will be divided among those daughter and his wife and daughter. So his wife and his daughter means son's wife and daughter. Okay. So shall we end this topic now today? I think I have spoken enough on this topic. I will share certainly this judgment which I was discussing regarding few judgments. Certainly I will share, and some of the judgments are from India Kanun, but I will better you take it from the take a citation, and then you can take it from the actually Supreme Court or High Court side. It will be more easier for you to read that. So I once again have to, I think I will stop, right? Once again I have to thank you for attending this webinar. And I told you, subscribe to the channel. You will be getting those link easily without any difficulty. Still, some people were asking why nothing was shared with me. It was not shared with you because it was loaded, video was loaded, but you didn't see the video because you probably have not subscribed the channel. So I am again requesting, subscribe to the channel, where you will get, whenever I load any this thing, many videos I have kept, I didn't get time to edit it. So kindly subscribe to the channel, you will get updated with this. And those who will be interested in doing detailed course on many of the topics which I am talking, right? I told revenue law, which I am upcoming and coming up with in maybe next few days, which are paid courses, and also on master in drafting of agreement. So those who are interested, then I will give you all the details about those courses, because they are very intense course, and it is not some 1 hour. It is intense detail. We go in minor things at detail. So I will share details about all those things. USC is not applicable, Jigna, so I don't see any reason to get into that. USC is not applicable. Maybe I will see that what is the effect of repeal or anything, but it's basically not applicable. Okay. And even that, Jigna, if you have anything, we'll discuss separately. So I will stop here. Good night. Thank you for attending this webinar. Take care. Bye bye. Keep learning yourself. Bye. Thank you.